will be run by renegade commissioners who took side with the petitioners in the 2022 Supreme Court petition. How will the 4 commissioners work with the Secretariat, which they could not agree on tallied and verified results, appointed a law firm to represent the Commission in court, and many other issues which are in public domain? The 4 commissioners violated the principles of Chapter 6 of the Constitution, and hence unacceptable to have the commissioners who are in office and the actions are contrary to the expectations of the Constitution. The independence of the Constitution is cardinal running of the affairs of the Commission. The 4 commissioners defiled the principles of neutrality, contrary to Article 81E(4) of the Constitution. They were openly working with one party in the 2022 election and thus openly biased. It's untenable to have commissioners who contravene the law and the Constitution, which they swore to abide to remain in office. The conduct in working in cohort with others to form government against the Constitution of Article 3(2) is unacceptable in open and democratic society. The heinous act of attacking the chairperson and other commissioners at Palmer's National Tallying Center, while in full glare of the public media, was meant to create national disharmony and violence. The end result would be post-election violence with severe consequences. The actions of the 4 commissioners amount to total insubordination of the Commission, contrary to Section 30 of the IEBC Act 2011. Several calls have been made for the commissioners to resign, but have not resigned, and in respect in which this petition is made, and pray that the matter be placed before the relevant House Committee, and as you may deem fit. The subject matter herein and the issues in which the petition is made are not pending before any court of law or constitutional or legal body. Hereof, we humble petitioner prays that the National Assembly, and due to the urgency of the matter, take the necessary steps as by Article 251(3) on removal of commissioners and grant the following prayers: to find the IEBC commissioners Irene Masit, Juliana Cherera, Francis Wanderi, and Julius Yangaya to have committed serious violations of the Constitution and the law, including contravention of Chapter 6 of the Constitution of Kenya. B, to find that the Independent Electoral and Boundary Commissioners Irene Masit, Juliana Cherera, Francis Wanderi, and Julius Yangaya are guilty of misconduct while performing their duties as members of the Commission. C, to find the IEBC commissioners Irene Masit, Juliana Cherera, Francis Wanderi, and Julius Nyangaya are incompetent to hold the office of commissioners, and your petitioner will ever pray. Chair, I'll now proceed to cite the specific areas to support the prayers. On the aspect of gross violation of the Constitution, which is Article 251A, I'll refer you to paragraph 5, paragraph 6, paragraph 7, 20, 22, 23, 24, 27, 31, 32, and 34. On gross misconduct, Chair, I'll refer you to paragraph 8, paragraph 10, paragraph 11, paragraph 30, and paragraph 15, 17, 34, and 36. Chair, on the last aspect of incompetence, which is Article 251, Article 251D, I'll refer you to paragraph 4, paragraph 10, paragraph 11, and paragraph 21. That's all, Chair.
Thank you. Council, you want to make remarks now, or do we seek clarification? Because now that he has testified, he will have to clarify himself. Then after that, we give you summing up rights. That would be better. Thank you very much. All right. Members, honorable members of Parliament, members of the committee, it will now be your turn to seek clarification from him. But before we proceed further, one, you have to give us briefly your own history. I mean, what do you do for a living? We want to hear from you. And why have you brought this petition? What has driven you to bring the petition? Do that as a form of your introduction, After, you also clarify that in your petition, throughout the body, you are petitioning this House to make findings against a commissioner known as Julius Nyang'aya. I want us to just reconsider with your counsel, who exactly is Julius Nyang'aya, and is he a commissioner? Because that is very important, so that we know your petition is directed against which person. You've also named somebody as Cherere.
Yes.
Right? Confirm that you are going against Cherere or somebody else, because it's vitally important that we know. Right? You just clarify what your position is, and then in your prayers you've brought this under Article 251(3), and you brought it to Parliament. What is Parliament supposed to do? If that you don't know, your counsel is going to do it, because it involves interpretation of an article of the Constitution. That is legal in nature. And now that you have an advocate, I think we don't have to belabor the point, because the advocate can clarify. So that is from me. I request you to make a note of them so that you can now take 2 or 3, and then after that we continue. So the first one is just introduce yourself, what you do, and what drives you to bring this petition. Number 2, tell us who Julius Nyang'aya and Juliana Cherere are, whether they are commissioners or what your position is. And number 3, now confirm what you want this committee to do for you in terms of Article 251(3) of the Constitution. Thank you. That is all from me. Vice Chair.
Thank you very much, Chairman. Petitioner and counsel representing petitioner. Good morning.
Good morning.
Just clarification, and also, number 1, you rely on the media statements that the 4 impugned commissioners had at Serena Hotel, and you are saying that their press statement and that of Raila Odinga, the Azimio presidential candidate at the time, were similar, and that because they were similar, you say then they must have been working in consonance. Is that so? My clarification is, would it be possible, would it be conceivable that people can also naturally think in a similar way, especially when they are addressing a similar issue? That it is possible for people, even without talking, to think in a similar manner. Number 2, you have also stated that the commissioners were proxies of external forces in your petition. What evidence do you have to demonstrate that they were actually proxies of external forces? What evidence, other than just a mere allegation, what evidence do you have that they were forces of external forces? And finally, on the question of incompetence. Incompetence is one of the grounds contemplated under Article 251 in terms of when you want to remove a commissioner of an independent, of a constitutional body or an independent office. And I'm happy at the end of your presentation, you have referred us to the specific paragraphs in your petition that speak to the grounds that you rely on. One of the paragraphs that you have referred us in terms of incompetence is paragraph 10 of your petition. I don't know. And paragraph 10 says the 4 commissioners appointed a law firm to act for the commissioners against blah, 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 blah. So my question is, how does appointing a law firm, how does appointing a law firm become incompetence? Where is the connection? I have appointed a law firm. By appointing a law firm, do I become incompetent? Thank you very much.
Yes. Honorable Michael Mushira from Ojoro Rock.
Thank you, Chair. Mine is just one. With regard to paragraph 10, about the 4 commissioners procuring the services of a law firm to represent them in a court of law. I would like a clarification on what would be the right procedure about appointment of the service providers to provision of these services with regard to the 4 commissioners. Thank you, Chair.
Thank you, Chair. Michael Ann would like to respond to the questions already.
Let us respond, then after that we take another set.
Chair, in my introduction, I'd like to state that I'm an advocate of the High Court of Kenya. That is what I do for a living. Secondly, I'd like to quote Warren Buffett, who said that when someone is sitting under a shade, someone planted a tree long time ago.
If you can be better audible, please.
I'm quoting Warren Buffett, who said that someone sitting under a shade means that someone planted that tree long time ago. I'm inspired by what others have done in improving our democratic space and ensuring that we have a country governed by the rule of law, whereby every person, every state officer, every individual given a duty to perform in a high office, in independent commissions and other higher-ranking positions, should perform their duties in accordance with the law. We are aware that for this Constitution 2010 that was promulgated, so many people suffered, so many people shed their blood. Some are still alive, they're still suffering, so that we gave ourselves this Constitution. I'm inspired to say, by those actions, and to say that in furthering the democratic space and good governance, I decided to pursue this route to ensure that when people are given such mundane duties to perform in independent offices, whereby they are governed by the Constitution and the law, they must perform them in tandem with the oath of office and everything that pertains to that office. That is my inspiration. That is the reason why I moved, when I realized that the actions of the commissioners, in my view, in my opinion, and my understanding as an advocate, were outside their mandate. They were performing their duties contrary to the law and the Constitution. That's the end of my introduction. The second part is with regard to, as my counsel is confirming the name for Nyangaya, I want to state that the name for Cherera is an error, and I believe that this committee, being a quasi-judicial committee, will not give undue regard to technicalities. It's an error, but the name is Cherera, not Cherere. It was a typical error. My counsel is confirming Nyangaya, but I know Nyangaya is a commissioner, so the first name is going to be confirmed, but I'll clarify that later. Number 3, Article 251, where I grounded my prayers, I'll read verbatim. The National Assembly shall consider the petition, and if it's satisfied that it discloses a ground that under Clause 1, shall send the petition to the President. A proper reading of the whole of Article 251 informs us that the procedure, or informs us the procedure of removal of commissioners holding independent offices, or in independent offices, or in commissions. That article at 251.3 mandates this committee, which is the Parliament, the committee and Parliament under the same thing, if they find that there are grounds that I've cited, the threshold is met, you forward the petition to the president to appoint a tribunal. The whole reading of that article will guide. I'm sure, Chair, I've seen most of your members are advocates. The whole reading of Article 251 is a clear point of that. At the end of these proceedings, if there is a finding that the grounds have been disclosed for removal of a commissioner, the duty of the committee in Parliament is to forward the decision to the President to establish a tribunal. So the grounding of Article 251 was where Parliament performs its duty of forwarding the petition to the President to perform his constitutional duty. On the issue of media statements, I applied the duck test. If it swims like a duck, walks like a duck, quacks like a duck, it's probably a duck. When people read similar things, their actions, their movements, their songs, their dancing are the same, they are probably reading from the same script. It can never be a coincidence. The media statements, the timing, for those who are following, I was following critically every step that was being taken, because the election of a president was a serious duty. We went to vote for all members of parliament, MCS, but the final one, which gave us long nights, counting, verification, was that of the president. I followed clearly, many Kenyans followed, and we saw that at the moment the 4 commissioners that I've cited were reading their statements, it could not take more than 5 minutes. It was actually systematically, even the TVs were sharing the screen to show the commissioners reading their statements, the KICC presser by the Asimio group. It was a well-coordinated move. So the duck test will confirm that they are one and the same people reading from the same script, probably even drafted by one person. At that level, you can draw inference as somebody who understands what's the movements of people. At the end of the day, you can draw an inference and say, these activities cannot be by coincidence. I'm moving to the question on proxies. I request this committee to apply the circumstantial evidence principle. Based on the duck test, you can draw a nexus. The connection, the link can be seen. The clear action of the IEBC commissioners from the day at the National Tallying Center, their movement from National Tallying Center to Serena, at the same time, there were activities by one function, which I can clearly say is Azimio, in trying to cause chaos at Bomas. They even issued statements, media statements, some few minutes, the IEBC commissioners are issuing statements. The following day, nearly at the same time, they're issuing statements of similar nature. The percentages were quoted as not by Cherera, and the other figures which were quoted by Raila Odinga were nearly the same in terms of saying that the presidential election has not reached the 50+1%. The angle, the lenses they had were the same. They were saying the 50+1% has not been achieved. The true present statements had similar objective. So there's a nexus, there's a link, and there's a connection. Paragraph 10 on incompetence. Every officer, a senior officer at the level of a commissioner, or even a vice chairperson of a commission, understands should or must understand the procurement procedures. A procurement procedure under the laws of Kenya, in all institutions, including parliament, are known. Somebody at the level of a commissioner cannot purport to appoint a law firm one night, which was not pre-qualified. That action means or shows us that there is lack of understanding or failure to comprehend the activities they were doing by appointing a law firm. It's incompetence. Division of incompetence can be confirmed from an ordinary dictionary, and it will show you that somebody who does not perform his function successfully is an incompetent person. The appointment was nullified. The appointment of the law firm that they purported to have appointed was nullified, and they were never represented by the law firm as commissioners of IEBC. They were represented as independent individuals, or individuals in their own capacity, not as IEBC commissioners finally. There's also a question on procurement laws and procedures. I think by answering the incompetent question, I've answered the aspect of requirements for advertisement. In procurement laws, you have to advertise. People bring their pre-qualification of their bids. All those procedures are known. I'll not belabor so much on them.
Thank you. Thank you, Geoffrey. Let's take the next set of questions from clarification from the remaining three. Honorable Soro.
Thank you very much, Chair. I'm happy that the petitioner is an advocate, and you can be able to respond to some questions. So I need some clarity. Number one, whether the petitioner is a member of any political party. He could be here, sent by a certain political party, just like he claims that some of the commissioners were biased. Possibly he's here to represent a certain political party. And as he confirms, of course, we'll have to check the status also to be sure that is that belongs to that party. Number two, he relies mostly, petitioner, you rely your petition on Article 81 on the principles of electoral system, basic principles of electoral system. You rely on Article 3.2, where you claim, with allegations that they attempted to establish a government, otherwise, as the article, of course, provides, other than that, that is in compliance with the Constitution. I need to know at what point did the four commissioners, showed or rather displayed, a direction that created a perception that they wanted to, instill another government other than what is constitutionally provided, because that is where you've placed your reliance on. Number three, Section 86, Section 26 of the IEBC Act, where you also rely on, you claim that they were taking directions from some quarters. In the entire story, besides the link that you display, you try to explain the link of press conference in Serena by the Cherera team and Azimio team. I want proof on being taken control by external forces. Does a press display that they were under control? Is there a meeting that you have, or a video, CCTV that displays that they had a meeting somewhere, with some outside quarters, and then they came out? I mean, really, we can't just say because they came out, because again, there is as I said with the other petitioner, there is a thin line between freedom of expression under Article 33 and such. So we need to know how these people were getting directions. And also in Section 30, where now you want to place your case mostly in terms of the offenses, it provides for the obstruction. They tried, the perception you've placed before this committee is that the four commissioners wanted to obstruct the commission from discharging their duties. At what point were they obstructing? Did they succeed to obstruct? Eventually they expressed themselves, but there was no obstruction. So how did they obstruct? At what stage did they obstruct the particular four commissioners? And finally, on procurement, I'll draw your attention on Article 227 of the Constitution and on state organs and everything and how they do their procurement. We should be fair, equitable, as you know, transparent, competitive, and cost-effective. And at this point, of course, at this very point of procuring the services of an advocate, you really can't say that they ought to have advertised the services of an advocate, because clearly they had to pick from the advocates that are pre-qualified. So the process of pre-qualification had already been done. So I want you to help me understand that what particular principle of procurement under Article 227 did they violate? Was it on fairness? Was it on equitability? Was it on transparency? Was it on competitiveness? Because if it was on competitiveness, then what happened on the other, the other commissioners? Is it because they had no local standard to procure? And is it because they also felt that the other commissioners' choice of an advocate wasn't cost-effective, and they decided, of course, to engage a cost-effective system, which is one of the principles of procurement in terms of, state offices procurement rules? Thank you very much, Chair.
Thank you. Good. I hope you've noted that very well.
Yes, Chair, I think just to request, that's it. The sets of questions are growing. I think
all right.
They're around 6 now. 5,
you 6. Have had 6 from one person.
Around 5.
5 from one person.
I think
you want to answer that?
Yes.
All right, thank you. Then we will go to Eddie and John after that.
Sure. On the first part, indeed, like any other Kenyan citizen, I'm a member of a political party, and specifically UDA. In moving this committee through a petition, I'm not instructed by UDA or any other agent. I'm acting on my own capacity as a citizen who loves the rule of law, who cherishes good governance and democracy. Therefore, my being a member of a political party does not hamper me from proceeding to take an action that is allowed by the Constitution.
Chair, just on that point, I think the petitioner should clarify whether he is an official of the UDA or a member with no, he has no other responsibilities of being beyond membership, possibly. Please.
Chair, I'm an ordinary member of the party. I'm very sure my learned friend who is a member of this committee understands the categories of membership of a party. Therefore, there are those who are privileged at the higher level, like members, but I'm an honorary member, so I do not have any other position, whether it's an official, and I've never performed any other official capacity in the party. On the aspect of Article 3.2, an attempt to establish a government other than provided for in the Constitution. The activities of which were witnessed at Bomas, the National Tallying Center, the chaos. You realize that Kenyans were anxious. On my part, actually my heart skipped a bit. It was terrifying to see a chairperson of an independent commission being attacked physically. It was a way of asking other Kenyans to take arms. People belonging to his community could have risen and said our person is being attacked. In the melee, and if that was to happen in other parts of the country, because if an individual is attacked physically, he belongs to a community, he's a family member, he's somebody of highly regarded in the society, an attack on that person and other commissioners was a way of showing that the country should proceed to engage each other on violence. It was an invitation by those who committed those acts to violence. And that one was preceded by the presser, or it was actually happening at the same time. I cannot tell you who was coordinating the activities, but behind the scenes, there must have been a coordinator. Attack the commissioners, make a press statement, let Kenyans be in a state of anxiety, put the country in anarchy. An attempt to establish that government outside the constitution can be achieved if there's anarchy, there's a state of lawlessness, violence everywhere, and at that point, the chairman was not to declare a result. There was a deadline. If the chairman was to be attacked to a level whereby he was not going to perform his duties, the next thing would be there was no result. You cannot go to the Supreme Court to challenge anything because there's no result. What would have happened? The term of the president has come to an end. Any other way of bringing in a government outside this constitution was supposed to have been activated as by what happened on that day. Any other person outside the Kenya who are following the proceedings, those who know what happens in terms of coups, most of them are holding their breath because it was a moment which this country should never witness again. Section 26 of the IEBC Act, that one can be read together with Article 249 because it's all about the independence. Let me just read verbatim 249. (49)(2). The commissioners and the holders of independent offices are subject only to the Constitution and the law, and independent and not subject to direction or control by any person or authority. The way the commissioners were conducting themselves, the 4 commissioners, it was clear that they were not independent. I've given so many instances on the connection, the nexus between them and other forces. I do not need to belabor so much because an independent commissioner performs his duties independently as by the law and the constitution. The activities were well coordinated, orchestrated by other people, which evidence may be adduced at a higher level, or because my understanding of the petition hearing is that as per the procedures, there's the act governing. There was no need to attach an affidavit. Actually, I can quote Section 3 of the Petition to Parliament Procedures Act 3K. A petition to Parliament shall be in the form set out in the schedule and shall, K, not have any letters, affidavits, or other documents annexed to it. The member alluded to freedom of expression. We all have freedoms of expression, but depending on the capacity that you're holding, the office that you're holding, your freedom is limited, and express yourself in an official capacity or acting in person. If the commissioners were to come out and declare that they were making statements in their personal capacity, they would have enjoyed fully their freedom of expression. Being members of the commission, they were governed by the IEBC Act and all the relevant laws governing their activities and their operations. So their freedom of expression was limited to the extent that their activities, performance of duties and their official capacity should be limited to official press statements by a secretariat or the chairperson or any spokesperson that they have appointed as a commission. Section 30 on the offenses. Obstruction of the performance of duties of the commission or the chairperson or any person in the commission is a criminal offense. And I can read the section 30, IEBC Act. A member or employee of the commission who knowingly subverts the process of free and fair elections or who knowingly obstructs the commission in the discharge of its functions or otherwise interferes with the functions of the commission commits an offense and is liable on conviction to a term of imprisonment not exceeding 3 years or to a fine of not more than 1 million shillings or both. For that to be achieved, you don't need to be physically present. Obstruction can happen in so many ways. It can be physical, or any other means. We saw physical obstruction, not by the members I've quoted to be removed, but their actions and activities of interfering, because the information by the chairperson that came out was that there were other considerations before they moved to Serena. They were supporting tampering of the results, and that in itself is also obstruction. They may not have been physical assaults on the chairperson by the commissioners, but all the activities compounded together result to obstruction of the performance of the commission action functions. The member chair also requested me to address Article 227 on procurement. We all understand that being members of the committee, procurement functions falls to a secretariat. In Parliament, there's a PSC that conducts the functions of ensuring that all members are properly resourced. It cannot be members of Parliament to go and procure. In the same way, commissioners have delegated that duty. IEBC commissioners gave the mandate to the secretariat, who carries out all the procurement procedures and regulations. The commissioners could not wake up and say they have appointed a certain law firm. Therefore, the issues of whether it was transparent, it was cheaper, or any other means do not arise.
Thank you very much. I think that answers it. Let's hear from
Mr. Chairman, just for one clarification to tie for Wakili Moreo. Everything that you are saying, I understand you to be saying there is reasonable inferences can be drawn to show a pattern, to show these people were doing something. And you are also saying, I get you to be saying, and I wanted you to be clear whether this is your evidence, that there was an attempt to subvert the popular will of the people, which, as you know, as an advocate, is also treasonable. So that are you on record that your evidence is that the commissioners attempted to subvert the popular will of the people, which is treasonable?
Yes, being an advocate, I think you understand the question.
Yes, but the wording that subversion of the will of the people is treasonable, I think we can go back and confirm from the penal code. Those are not the words in the penal code. Therefore, I'll answer it this way, that it's true that I'm on record to say that they attempted to subvert the will of the people. The will of the people ends at the ballot. Any other action to diversify, to alter, to tamper with that decision at the ballot is actually subversion of the will of the people, because the will of the people is a democratic process. People exercise their democratic right to vote and to establish a government as per the Constitution. So any other person thinking, attempting, or performing any other activity to subvert the will of the people will have committed, will have violated the Constitution. Therefore, the wordings of subversion of the will of the people is not, in the wordings of the penal code, is not a treasonable offense.
Sorry, what have you said?
I'm saying
Subversion of the will of the people is not treason.
the wording, if you can go and confirm the penal code, the wording.
What is treason?
Treason. For instance, when someone tries to overthrow a sitting president, that is a treason. And at that time, they were not they were not attempting to overthrow a sitting president. They were trying to subvert or to tamper with the decision of the people.
What would be the end result?
Violence, anarchy. Yes.
Thank you. All right, let's go to Wakili Edward Moreo.
Thank
He
you,
has
Chairman.
a few questions to ask.
Thank you, Chairman. The petition has come up with a nexus theory. And as committee, we appreciate your persuasion that you are coming under Article 1 of the Constitution to support Article 251. And by that, I see the theory of nexus, whereby all these commissioners, the four of them, the respondents, were appointed almost at the same time. By the sweep of your petition, you are seeking for the same four commissioners to be swept out of office at the same time. I would like kindly clarify to us the nexus on why the four and not the rest. Number two, you have also connected in your testimony that these commissioners, there is going to be an element whereby in the event the sitting three commissioners exit office in January 2023, the natural course will be one of the respondents will take over as the chair of the commission. With your petition here, what you're trying to persuade the committee is that you want, by January 2023, not to have a single commissioner in office. Kindly guide us, because as a responsible citizen under Article 1, and also I'm sure you're also a student of Shakespeare, in the Merchant of Venice, if you want a pound of flesh, then you cannot spill the blood. And therefore, there will be a legal and constitutional crisis which you're trying to instigate. How do you mitigate that? Thank you, Chair.
Can I proceed, Chair?
John, to put intervention, he answers both together.
Thank you. Article 251, under which you have brought this particular petition, sets out the grounds. And you have cited one of the grounds is serious violation of the Constitution. That indicates that it's not just any violation of the Constitution that will lead to removal from the office. I have looked at your petition, and you have basically cited only 3 articles of the Constitution. Article 1, Article 2, Article 81E. I'm looking at those articles, and my question is this. The Commission has 7 commissioners, and you've raised issues about the performance of the Commission. Why, in your view, will you fix the 4 commissioners and leave the rest of the other 3 commissioners? Or is your interest driven by what you have said at paragraph 29 of your petition, that the structure and composition of the commission will be dented if left to the 4 commissioners? It's unimaginable how the commission will be run by renegade. You have already classified them as renegade commissioners. What is your finding of renegade commissioners? At paragraph 35, you have said the heinous act of attacking the chairperson and other commissioners, Bomas National Tallying Center in the full was meant to create national. Do you have any videos or any of any of these 4 commissioners attacking people at Bomas Center? 2, freedom of expression is a hallowed concept in our Constitution. Freedom of expression and the right to hold opinions. Your petition is grounded by the pressers which you say were given on that particular day. What is your take on the freedom of expression, the right to hold freedom of expression, alongside the grounds which you have cited? Because in my view, the commissioners were actually exercising the right to hold opinions, express opinions. What is your take on that? Then finally, you have made a blanket assertion at paragraph 32 that these commissioners were openly working with one party in the 2022 election and thus openly biased. You will agree with me that an election is a process. Is a process, but you have made a blanket assertion that in the whole of the 2022 general election, they were openly working with one team. I need a clarification basically on that. And then finally, there are sanctions, criminal sanctions imposed by Section 30 of the IEBC Act, that if you want to subvert the will of the people, there are criminal sanctions that are applied to that. Have you taken advantage of those other avenues that are provided before taking this avenue of bringing this petition here? Thank you, Chair.
All right. Thank you. Geoffrey, you may now take that. You may just respond to that set.
I will start by quoting or reading Proverbs chapter 28, verses 1, which says, "The wicked flee even when no one pursues them, but the righteous are bold like a lion." That takes me to answer the question on removal of the 4 commissioners and not the rest. Their movement, the indecision, is expressed by the chairperson in his statements that there was an issue concerning the outcome of the result, and the 4 commissioners were not agreeing to the chairperson to proceed according to the law, and they moved to do the action of reading a presser. They were running away from the cardinal duty that they were given to perform. They did not want to follow the law. They wanted the law of the jungle to take its course. That in itself is a sign that the commissioners were not ready to abide by the Constitution. Giving me the mandate as a citizen of this country and as a person, that Article 251 gives me that mandate to move the Parliament after looking at the 4 commissioners and not the other 3 who remained boldly to perform their cardinal duty to declare the result and deliver this country from the abscess of, or from the quagmire that we were in at that time. It was the boldness of the 3 commissioners that kept this country on the right path. The issue of a crisis, constitutional crisis. At certain times, we must, or we will find ourselves in certain crisis. This will not be the first crisis. If it will happen, it will not be the first or the last. And there's always a way out of the crisis. We were in a crisis, 2008. We found our way out. Now, at that time, it was a bigger crisis concerning the leadership, the president. We had a prime minister so that we solved the issue. Now we are looking at the IEBC Commission. There's no impending general election at the corner. What you know is around the corner is the issue of the elimination of the boundaries. I'm aware that there's a vacancy which has been advertised for the 3 commissioners who are exiting. Therefore, the process of appointing them will kick off immediately. And we'll have commissioners. If the 4 will be removed by the tribunal and confirmed by the president, the process of appointing others will kick off. The crisis of having no commissioner will cross the bridge when you come to it. But at the moment, we must put the country on the right path.
As you answer the question, you are also aware that there are by-elections that are supposed to be conducted by the Commission, tied to it.
As we speak, there are dates for the by-elections. Most of them are in December. I'm not aware whether there's another one in January, February. They have not advertised or communicated. But the ones in December, the Commission also will be in the office. There are 30 days for the other procedures to be followed. Parliament is not yet done. So the commissioners will perform their duties as they will be at the office at that time. They will be in office. So the by-elections will be conducted successfully. Unless any other by-election comes, we'll cross the bridge when we come to it.
Chairman, the respondent, when you say that you cross the bridge when you get there, don't you think that's a statement of carelessness? Because this country will be thrown in crisis because there are a number of activities happening. The commission is not an ad hoc committee, an ad hoc commission. Their work proceeding, and you have nipped the bud at the head, whereby you remove the entire commissioners from office. Don't you find that that's maybe an act of carelessness?
Chair, I've mentioned that, just to answer the member, I've mentioned that at the moment, the process of appointing the other commissioners will kick off. The three, I'm not sure whether they are on terminal leave, should be out by January, and the process of appointing them will kick off. We don't even know when the removal of the 4 will come to an end. We do not have a definite date at the moment. Maybe by the time they'll be removed, the other 3 will be in office. That's why I said we'll cross the bridge when we come to it. A constitutional crisis may come. This will not be the first one, and if it happens, others will happen. And a situation whereby all the commissioners die in office, will we say there's no commission? They may all day, they may all die in one day. What will we say the following day?
That's a little bit presumptuous, but
them
dying,
God forbid, God
them
forbid.
dying, I don't know in what, all of them one day. All right, thank you very much. Just continue with your responses, please.
The issue of videos. I quoted the Section 3 of the Parliamentary Procedures Act. No, let me just. Petition to Parliament Procedures Act. That there's no requirement to avail evidence to this committee in form of a affidavit or annexure. Therefore, if there are videos that I have as evidence, will be adduced, most probably at a different level.
Sorry, but our question was really, we don't ask him to produce him at this. Does he have that kind of evidence, even if he can't produce it to us, because of our mandate and our limitations?
Chair, with respect to the specific question on commissioners attacking fellow commissioners, there is no video. I do not have it with me. And even in the higher level, I cannot produce such a video because they did not perform that act. Expression, freedom of expression. I had initially answered it, but I can proceed to answer because the member also brought it up. I've categorized the freedoms and said freedom of expression belongs to all of us. The Constitution grants us the right to make opinions, I can make opinion, I can say anything that I like as long as I'm not offending anyone. That's a limitation in itself, because if I make statements that are going to cause chaos, that's a limitation. As commissioners, their statements, while performing the function of a commissioner, is limited to official communication, my understanding. Official communication of the commission, decisions of the commission, and if they do not agree, it can be recorded in their own boardrooms. They have a way of dealing with and catering issues of disagreements in decision making. It was the first time for us to witness commissioners coming out to make such statements in the press. I'm very sure your own Parliamentary Service Commission have their ways of dealing with issues that are not agreeable. They cannot come to the media and tell us their issues. Chair, the freedom we are looking at, and we are aware that the Constitution provides that rights can be limited as far as it is agreeable in a democratic society. The limitation I've mentioned are and should be to protect the independent institutions. Therefore, if you allow freedom of expressions and opinions in serious offices in the nature of IEBC, we will not see good governance, we will not see progress, we will not make progress as a nation. We'll always be in quagmires, we'll always be having the crisis, the constitutional crisis, because one day this group will say we disagreed, we are leaving office, the other one can also come and say we are also leaving office, because they've disagreed on something. There are procedures of dealing with disagreements, and they can iron out in their boardroom, failure to which they have procedures of dealing with them. Opinions and expressions that are likely to cause violence, that are likely to cause anarchy, should not be entertained and should be dealt with as by the law and the Constitution. The aspect of being openly biased. My petition, in its entirety, is limited to the declaration of the results and the aftermath. The entire reading of my petition did not go to the employment, the time of they came to office, and all the activities that they did before the elections. I've premised my petition on the activities of National Talent Center, the press statements at Serena, the press statements at KICC, and all the activities put together. But I did not mean, and the entire reading can guide the committee to show that I did not mean they were openly working together for the entire election period. They were working together at that period with intent to cause chaos, as I've stated earlier, and to subvert the will of the people. The sanctions under Article 30. I've cited that section to show the seriousness of the violations that the commissioners breached the law, the Constitution. The aspect of being charged in a court of law belongs to another forum. I have not reported or complained to the police. I don't have an OB to that extent. But my purpose was to show that they obstructed, they performed activities which could have led to non-declaration of results. So therefore, the police also have a mandate in their own capacity to investigate. And on my personal capacity, I have not reported, I don't have an OB, but my intention was to show the extent of violations, serious violations, by the commissioners.
So your clarification is that you have not moved any other agency. This is the first.
Yes.
Trying to move.
Yes, Chair.
Are you through with your responses to all the questions?
Yes, I believe I'm done.
Basically, you are through. Okay.
There was one aspect
Yes.
that we were
Yes.
in the process of clarification.
Okay.
Because of the engagements with the questions, I have not confirmed the full name of Nyangaya, Justice Nyangaya, Commissioner Nyangaya. I'm just confirming in a minute.
You're still confirming?
Yes.
All right. In the meantime, as we wind up, let's hear from Honorable Kagusha. I think he wants one more clarification.
Yeah, just a small clarification, Mr. Langat. From your statement and from your petition, and also from what you have told us, it seems like you are connecting quite a bit of these commissioners to one side of the political divide. You seem to have a problem with them having to be on the same side in the petition that was at the Supreme Court. In fact, you highlight how Commissioner Julius Nyangaya, in his capacity as the chair of ICT committee, was able to access and supply RTCA logs in support of that petition. Do you feel like there's a connection between that and do you feel like there's a connection between the four commissioners and that one particular side of the political divide that you are alluding to, and that in yesterday's presentation by petitioners, again the bigwigs of that political party or that political coalition were also seen to be in support of the four commissioners. Do you kind of now think there's a connection between the appearance and the support of the 4 commissioners and what was happening before the election, during the election, and after the election in the Supreme Court of Law.
What are your thoughts on that?
Chair, my petition, as it is now, concerns the activities just after the election and during the petition. What happened yesterday, it's for the committee to draw an inference because everybody, they were present. The nexus, the committee will make addition on that concerning yesterday, but the link that I was bringing out was at that time. And maybe what happened yesterday could just be the last nail in the coffin.
Thank you. Thank you very much. I think
I have confirmed, Chair, sorry.
You
I've
have confirmed
the name.
The name is who?
Justus Nyangaya, not Julius Nyangaya. The name Julius and Justus in pronunciation.
So your petition relates to a commissioner by the name Justus
Nyangaya.
Nyangaya. And you wish to make that clarification?
Yes, Justus Nyangaya.
And
Chair.
you had also a Cherere somewhere.
I'd clarified and
You
said
clarified
it's
it is Juliana Cherera
yes, Chair.
and not what. So what do you ask this committee to do now as regards those corrections?
I like the committee to adopt my corrections and to have the name to read Juliana Cherera and Justus Nyangaya, and not as earlier typed in my petition. If the committee so permits.
Thank you. We have noted that. Now a few minutes to counsel, but I caution him really whether he has anything to say. We didn't know initially that your client is an advocate. We know how difficult it is to represent an advocate, because soon you'll be stopped on your tracks that what you are saying is not what he wants you to say, all right? And that he would have said it differently away from what you're saying. But with all that, because your counsel, we give you 10 minutes to make a sum up.
Yes, thank you, Chair and honorable members. I am quite humbled by my client's confirmation on issues touching on this petition. He has been very articulate, and I think the Commission has noted almost everything. All the answers, I believe, are with the Commission as we talk. I'll just wish to pray and submit that this committee do find that the commissioners listed as Irene Masid, Juliana Cherera, Francis Wanderi, and Justus Nyangaya committed serious violation of the Constitution and the law, and even contravene Chapter 6 of the Constitution. I wish to pray as well, as per the petition, that this committee do find that the IEBC commissioners, Irene Masid, Juliana Cherera, Francis Wanderi, and Justus Nyangaya are guilty of these gross violations, and that to also find that the IEBC commissioners, namely Irene Masid, Juliana Cherera, Francis Wanderi, and Justus Nyangaya are incompetent to hold the office of the commissioners of IEBC, and therefore recommend to Parliament that the President do constitute a tribunal to investigate and take evidence as per the law and remove them from office. Thank you, Chair. Thank you, members. Thank you for listening to our client. Thank you for listening to us. Thank you.
Thank you. Thank you, Advocate Nelson Mutai. I think we have heard you in full, unless there is anybody who says there are segments that are left out. We've heard what you have to say to support your petition. We have heard your prayers to the committee, which prayers will have to be sent to the National Assembly for the National Assembly to make its decision in one way or the other. So we thank you very much for the presentations, and unless there is anything else to be said, Yes, unless there is anything else to be said, we will bring your representations to a close at this level. But we got to advise you, Wakili and client, that on Monday and Tuesday, we have allocated time for the respondents, the 4 commissioners, to appear before us so that they can also make their own representations in compliance with the rules of natural justice, that we must afford every one of them a fair hearing. So during that hearing, you're welcome to come and cross-examine them just in case you feel it is necessary. It will be at 10 o'clock and again at 2 p.m. and on Tuesday from 10 o'clock and again at 2 p.m. to cover the 4 persons you have named as respondents. So you are welcome to come and present your cross-examination questions during that time. So with those remarks, we now confirm that you are discharged and you may leave the chambers as it pleases you. Thank you. There is also, I'm told there is a cup of tea somewhere. No, not by us, but by the House of Parliament. So you don't have to feel it's a committee offering the tea. It's Parliament that is offering the tea in consonance with its practices that continuously it has to entertain its guests using taxpayers' money. It's not our money. So it is your own money. You can have a cup of tea as you exit the chamber. Thank you very much.
Thank you, Chair. Thank you, members. Have a good day.
We are convening at 2 o'clock, isn't it? At 2 o'clock. All right. Honorable members and members of the press, that brings us to the close of this morning's session. The next session is at 2 p.m. So we will convene here at 2 p.m. sharp to hear the 4th petitioner as we have programmed, as we put in the schedule, and as we advertised out there. So you may take your break now to come back at 2 p.m. Thank you very, very much. Let's meet that particular time. The session stands adjourned. Very good. Where do you want to? Or where do you want to go? Members.